Hey YouTube family and GN subs, hope you're having a wonderful week. And today we have some really good information for you. There's a case that came out of the Ninth Circuit, Sandra Munoz versus State Department, a marriage case, huge win for immigrants advocates, and I will go through the standard for you. It can be used in your cases. It's unbelievable. You know, we do a lot of videos on marriage cases. This is a big one, folks. For those of you who are new to the channel, my name is Humberto, Gray Attorney at Law. I am here in Los Angeles, sunny Southern California, and I bring good news to you. That's what I do. Today is all about good news. A lot of good stuff, and you can get me at GrayLaw.com. My email, hrg@graylaw.com. I have no WhatsApp numbers, none of that stuff. So if you see a number in the comment section, that's not me, okay? You go hrg@graylaw.com and you can get me. And today I have a question of the week that I will post at the end of this video. Also a comment that was wonderful, really good comment. I will post that as well. So stay tuned and let's get at it. We got a lot to unpack. All right, good news. October 5th, 2022. Sandra Munoz versus State Department, huge case. Let me roll it out for you. So what happened was, it's a marriage case, and the interview was held in El Salvador. State Department denied the case and said the immigrant would be engaged in, quote, unlawful activity. I put a link in the description box below. You can read this case. Really important case, all right? So for 3 years, the State Department does nothing, and a lawsuit was filed. Reason for the lawsuit? What is unlawful activity? That is no legal standard by which to deny a case. So they sued, and Ninth Circuit said, you're absolutely right. A decision must provide a factual basis, on which someone can appeal. They have to know what is the reason for the denial. What is unlawful act? So I guess what happened was, in reality, the immigrant had tattoos. The consul officer thought they were gang related. They were not. And in fact, one tattoo was a Christian tattoo. In any event, they thought that, so they denied it for some reason, unlawful. Ninth Circuit said a decision providing factual basis of the reason for the denial must be made within 30 days of the interview. Folks, that is huge. That is huge. That can be applied, I would say, to USCIS as well. I'm sure there's going to be many lawsuits that are being brought under the standard, and it's fantastic, folks. That's a huge win for immigrants' rights. All right, another bit of good news. COVID flexibility extended. I've talked about this for months and months, whereby on appeals, generally, you have to respond within 30 days for notice of intent to deny, notice of intent to revoke, notice of intent to rescind. You only have until the date provided by USCIS to respond. Well, COVID flexibility said that you have an additional 60 days to respond to certain notices. Well, this has been extended until January 24th. 2023. That is fantastic news, folks. I was getting work because, we have clients that come to us, and usually they come when there's a week or two left. You have to respond to this notice of intent to deny. And I tell them, nope, don't worry. We have an additional 60 days to respond. So on the notice of intent to deny, notice of intent to terminate, notice of intent to rescind, the notices, generally, they will provide you with a due date. You have an additional 60 days from that due date to respond. On appeals from I-130s and I-140s and appeals from citizenship, you have 90 days from the date the decision was issued, okay? All right, so we talked a little bit before about fiscal numbers for employment-based applications. In 2022, for example, a record number of employment-based visas were issued, 281,000, almost double the 140,000 limit. Why? Because they take unused family cases and put it into the employment-based category. Well, for fiscal year 2023, which is from October 2022 to October 2023. That's immigration's fiscal year. They're estimating that there's going to be 197,000 visas in total that's going to be allocated to the employment-based category. 55,000 unused visas in 2022 is the estimate, so they will roll that over into the employment-based category. That is good news. Another bit of good news, there's good talk about H-1 spouses. Those are H-4, being able to obtain work authorization. Currently, you may not know this, under current law, if you have an approved I-140 employment-based petition, the spouse under H-4 can obtain a work authorization, an EAD. Also, if you've had an I-140 or a labor certification that is pending for a year or more, which continually allows you to extend your H-1 annually, the H-4 spouse is able to obtain work authorization. Well, there's talk in Congress, and advocates of immigration are pushing to have this policy put in place, as Obama did in the current situation in 2015. He added this provision allowing H-4s to be able to get work authorization. So they're talking about making it permanent, just any H-1, H-4s are able to obtain work authorization. It's done already. It's done in the E category. An E visa holder is able, the spouse is able to get work authorization. All right, there's another case is on the lookout, okay? This is Day versus Garland, okay? I put a link in the description box below. Check this out. This is regarding whether or not a marijuana conviction is what we call a crime involving moral turpitude, which means you can be deported from the United States. So there's two things, right? So Biden is pardoning 6,500 Americans who were convicted under marijuana provisions. And in this case, it's going to the Supreme Court. It's being challenged that marijuana convictions are not a crime involving moral turpitude. So Day is from Jamaica, permanent resident. He was convicted of bringing marijuana into the state of Virginia, convicted, and they deported him. So he's challenging this in the Supreme Court. And there's been some talk, quite a bit of talk, about the Supreme Court finally saying that unless it's an aggravated felon marijuana charge, that's like transporting tons of marijuana into the United States, et cetera, that simple convictions of marijuana use, et cetera, are not a crime involving moral turpitude. Watch this case, folks. I think it's going to happen. All right, let's go to the question of the week. This is a great question. If the U.S. citizen completes an application, it's called a DS-160, right, on behalf of the individual trying to come to the U.S., should that be done or not? That's a great question. It should not. You should make sure that the immigrant who is trying to come to the United States completes that application, because if you make a mistake on that person's behalf, they have to live with it, and it may result in the denial of that non-immigrant visa. So be careful, folks, all right? And then this comment, hey, Humberto, why don't you put your phone number on your videos so that you don't get fraudulent apps numbers, on the comment section and questions? That's a great idea. What I'm going to do is I'm going to put my email address, okay? hrg@graylaw.com. It's the only way you can get me. Hey, YouTube family, thanks so much for watching GrayLaw TV. Click below, like and subscribe, and we'll certainly see you next week, okay?